There was a lot of blood. There was so much blood you can taste it in your mouth.
He had a hatchet in the head twice. Nate also used a hammer and was striking her in the head.
You both took a big part of my life away. You took my better half away.
In September 2012, 78-year-old Barbara Olson of Sheboygan Falls, Wisconsin, was found dead in her garage by a family member. Investigators quickly turned their attention to her great-grandson Antonio Barbeau and his friend Nathan Paape. The two later admitted they had gone to Olson's home planning to rob her. Afterward, they searched through her belongings, took jewelry, her purse, and her car, which they later abandoned. Both boys were arrested and charged with first-degree intentional homicide.
At one point, she let them into the house, and he had a which he used the blunt end and struck her in the head at least twice. And then Nate also used a hammer and was striking her in the head.
As a prosecutor, you don't look at the Justin Bieber haircuts or their innocent faces. You look at what they did, whether they're 13 or whether they're 80. That's how I think all prosecutors look at people. You are how you act.
When you have two very different instruments that are differently shaped, it wouldn't surprise me if a competent medical professional could determine that this blow was this type of weapon and this blow was this type of weapon and which one was the blow. It wouldn't surprise me that they could do that.
Barbeau eventually accepted a plea deal and entered a no-contest plea, receiving a life sentence with the possibility of parole when he turns 50. Paape went to trial, and in June 2013, a jury found him guilty as a party to the crime. He too received a life sentence with parole eligibility set decades later. In 2016, Barbeau's sentence was upheld on appeal. In June 2024, Devontae Mitchell entered the Hyatt Regency Hotel in Milwaukee after panhandling nearby. Hotel staff tried to remove him, and during the struggle, he was restrained on the ground. Moments later, he became unresponsive. The medical examiner later ruled his death a homicide, noting that underlying health conditions and substances in his system contributed to the outcome. Authorities charged 4 hotel employees, Todd Erickson, Brandon Turner, Devin Johnson Carson, and Herbert Williamson, with felony murder.
Mr. Erickson, you've been charged with 1 count of felony murder as party to a crime.
This is an extremely serious charge. Felony murder is a homicide charge. There's significant exposure should Mr. Erickson be convicted, and I think that is relevant to the court's determination as to whether Mr. Erickson will continue to appear for court.
Over the following months, each man appeared in court.
Obviously, it happened. No question that the facts happened. Those will be sorted out at a trial.
Turner pled guilty to felony murder, while Williamson and Johnson Carson accepted misdemeanor battery charges in exchange for cooperation. Erickson, the last to face trial, also pled guilty. In September 2025, a judge sentenced all 4. None received prison time, instead facing probation or short sentences already served. The outcome left Mitchell's family frustrated, believing the penalties did not reflect the weight of their loss. In July 2022, 31-year-old Greg Najee Grimes, a well-loved football coach at Indercombe High School in Sacramento, was shot outside a downtown nightclub near 15th and L Streets. His death left the community in shock, as he was known for mentoring young athletes and giving back to the city where he grew up. After months of investigation, police identified Tajee Michael as the suspect. He was arrested in February 2024 in North Carolina and brought back to Sacramento.
This isn't just about one man, Mr. Michael, who used a firearm. It is bigger than that, and our community is hurt every day by the violence that we see on the streets with the use of guns.
In June 2025, Michael entered a plea deal, admitting guilt to murder and related charges. In the months after his funeral, Grimes' mother created the Greg Najee Grimes 212 Anchor Foundation, which now provides scholarships, raises awareness about violence, and supports youth programs.
I really search my own soul for this, because it is very difficult to fathom what it is I should be talking about with this person who so tragically impacted our lives. It's about valuing life. It's about purpose. It's about all the things that our son stood for.
During sentencing, Grimes' family and friends shared emotional statements, remembering his positive influence and calling for change to prevent future tragedies.
We know it won't change the course of what happened because we can't get Greg back, but we're hoping that it saves another person's life.
Michael also addressed the family, apologizing for the pain he caused. The judge ultimately sentenced Michael to 25 years to life in prison. In April 2017, 82-year-old Agnes Bram was found dead in the garage of her Middleton home. She had been renting a room there to John Jack Hamann, who quickly became the focus of the investigation. Court records later showed Hamann had a history of violent behavior, including a past conviction involving a neighbor. He was arrested soon after Bram's death, and his bail was set at $500,000. The case went to trial in August 2018. Testimony included statements from Hamann's own mother, as well as evidence that prosecutors said tied him directly to the crime.
The bruising of the right wrist can be consistent with being grabbed and having hard force applied to the wrist, or potentially impacting the surface with a blunt object, or being impacted by a blunt object as you're using your body as a shield between yourself and a weapon.
The defense suggested another person could have been involved, but the jury was not persuaded. By the end of the trial, Hamann was found guilty of first-degree intentional homicide. 2 months later, in October 2018, a judge sentenced him to life in prison without parole. In 2012, 20-year-old Andrew J. Meis legally purchased a weapon through an online dealer. The background check process cleared the sale because, under Wisconsin law, only individuals who are involuntarily committed or legally barred by a court can be denied firearm access. Meis had a history of psychiatric treatment, but since he had voluntarily sought help, it did not appear in the system.
A person can make a purchase online. They pay for it. They pay for the firearm in full at that point. So it's a pretty quick process. Very tough to make a judgment of someone's character or mental well-being in that short period of time.
Later that year, concerns grew when Meis reportedly told his psychiatrist he intended to harm 2 people, including neighbors and a friend. In December, he allegedly confronted a neighbor while armed, which led to police involvement. Prosecutors charged him with 2 counts of attempted first-degree intentional homicide.
The defendant apparently obtained a assault rifle clone recently, specifically for the purpose of shooting people. He has had some recent outpatient commitments as well as a recent inpatient psychiatric hospitalization. And there are, I think, continuing mental health issues.
Meis made his first court appearance in early 2013, where the judge set his bond at $200,000 and ordered a psychiatric evaluation to determine his competency.
He absolutely is, and I think that a past record of reaching out for help and reaching out for help in this case absolutely indicates that this is someone who wants to get better, who wants to be a functioning, productive member of society just like anybody else.
His attorney emphasized that Meis had a record of seeking treatment voluntarily, suggesting he wanted to improve his condition and avoid harm. In December 2024, 23-year-old Ryan Zadrozny was visiting Charlotte, North Carolina, when he was struck and killed while crossing West Moorhead Street. Police say the driver, 37-year-old Mache Ulysses Darby, was speeding at more than 100 miles per hour and impaired at the time. Darby was later arrested and charged with multiple felonies, including second-degree murder. The case gained additional attention because Darby had a prior conviction from a fatal hit-and-run in 2011, raising questions about repeat dangerous driving. In August 2025, Darby entered a plea deal in Mecklenburg County Court, pleading guilty to second-degree murder and related charges.
He always had a way of making everyone feel loved and cared for, no matter who it was.
Parents did everything right. I mean, they gave their life for him.
Ryan's loved ones remembered him as a kind and caring young man, while also urging changes to prevent similar tragedies in the future.
The heartache never ends. No amount of punishment is really going to justify or do anything to bring Ryan back.
During the sentencing, Darby apologized directly to Zadrozny's family, saying he was deeply sorry and that the tragedy could have been avoided. Darby was eventually sentenced to 16 years in prison. In Oconomowoc, Wisconsin, 87-year-old Alan Al Amy was driving his tractor to mow grass at his church when he was struck by an SUV near Allen Road and Orchard Circle. The driver sped off, leaving Amy critically injured. Police later confirmed he died from his injuries.
Damage so substantial that there's parts all over the road.
Investigators recovered vehicle parts from the road and, with help from surveillance and flock cameras, traced the SUV to 49-year-old Matthew Brennecke.
What would possess somebody to leave somebody in a state so badly that they take off unless they've got something else to hide.
Authorities say he tried to destroy evidence by smashing his phone and hiding the car under a tarp and branches on a friend's property.
Covering that car with a camouflage tarp, as well as putting branches all over it as well to make it blend in more with the scenery and in the woods.
Brennecke was arrested and charged with hit and run resulting in death. At his first court appearance, prosecutors emphasized his lengthy record, which included a prior hit and run conviction. They revealed that he admitted to clipping the tractor, but claimed he fled out of fear.
I don't believe that this is a violent offense.
Brennecke's defense argued that the victim may have fallen before the collision, but the judge ruled that such disputes should be addressed at trial. Brennecke's bond was set at $100,000 as the case moved forward. In April 2025, tragedy struck in South Fulton when Captain Helio Garcia of the city's police department lost his life in a head-on collision. Investigators said the other driver, Santoria Latrice McLean, had been traveling nearly twice the speed limit when she crossed the center line and hit Garcia's vehicle. At the hospital, her blood alcohol level tested well above the legal limit. Both drivers were treated, but Captain Garcia did not survive, leaving behind his wife, daughter, and colleagues who remembered him as a dedicated public servant. McLean was later charged with multiple offenses, including vehicular homicide and reckless driving. At her bond hearing, prosecutors emphasized her prior felony conviction and recent completion of probation, arguing she remained a risk to the community.
The devastation that it's caused not only for the family and the police department, it's been devastating. Lieutenant Garcia gave his life not only for the officers that are here, but for all these people that are in the galley. He served as a public servant for many, many years. There are so many resources that are available to people out there when they make the choice to drink and drive. Ubers, Lyfts. Those choices were not made that night. And the ultimate sacrifice that Captain Garcia faced by giving his life has been very hard for the agency and our community.
Members of the South Fulton Police Department filled the courtroom to support Garcia's family, while his daughter shared a letter about the heartbreak of losing her father. After hearing from all sides, the judge denied bond, ordering McLean to remain in custody as the case continues. In June 2011, tragedy struck Brookfield when businessman John Agerter was found dead inside his garage. Investigators later connected the case to Tommy Douyette and Lynn Hajny, alleging that Hajny believed Agerter owed money to her husband and enlisted Douyette's help. Douyette eventually admitted his role and pled guilty to party to the crime of first-degree reckless homicide.
State of Wisconsin versus Tommy Douyette. Appearances, please.
Mr. Douyette will be entering a guilty plea to the charge of first-degree reckless homicide.
First of all, is that fact true that you physically struck the victim?
Yes, sir.
Are all the other facts in the criminal complaint true and correct?
Yes, sir.
Mr. Douyette, to a now amended charge of party to the crime of first-degree reckless homicide, what is your plea?
Guilty.
As part of his deal, he also agreed to testify against Hajny. On October 9, 2012, a Waukesha County judge sentenced Douyette to 30 years in prison, followed by 20 years of extended supervision.
State versus Lynn Hajny.
I believe at this point, based upon my most recent discussions with her, that perhaps a mental health disease defense exists in this case.
Hajny also acknowledged her part in the plan later, received a sentence of 15 years and 9 months in prison, plus just over 5 years of supervision once released. In April 2016, was booked into the Milwaukee County Jail. After flooding his first cell, he was moved to solitary confinement, where jail staff shut off the water supply. Days passed, but the water was never restored. For a full week, Thomas remained in his cell without access to drinking water or a mattress. On April 24, 2016, he was found unresponsive and later pronounced dead. The medical examiner ruled the death a homicide, pointing to severe dehydration as the cause. The case quickly drew scrutiny. An inquest jury recommended charges, and by 2018, 3 staff members, Major Nancy Evans, Lieutenant Kashka Meters, and Officer James Ramsey Guy, were charged with misconduct and neglect.
And then they shut off the water. Is that right?
They went into the pipe chase, yes.
And then they locked him up. Is that right?
Mm-hmm.
And then they never let him up.
Investigators said Evans failed to preserve key surveillance video, while Meters and Ramsey Guy carried out and recorded the water shut off improperly.
Captain Gold is angry with me. He has an IA case. Now they want to make me the bad guy. I have nothing to hide in this. I don't condone any of this actions. at all.
The jail's medical provider, Armor Correctional Health Services, was also charged for falsifying records, and in 2022, it was found criminally guilty. Earlier in 2019, Milwaukee County and Armor had settled with Thomas's family for $6.75 million. In September 2012, 45-year-old Teresa Boone was found dead in Milwaukee's River West neighborhood at Kilbourne Reservoir Park. Investigators later identified James Donegan as the suspect. According to the complaint, Donegan believed people were following him and confronted Boone in the park. The medical examiner confirmed her death, and Donegan was charged with first-degree intentional homicide and armed robbery.
I'm specifically requesting under 971-14 sub 2 that the court order an inpatient examination based on the defendant's physical and mental health needs.
During the court process, it became clear Donegan was struggling with severe mental health issues. His father, a Milwaukee County judge, shared that his son had stopped taking medication and was experiencing delusions.
I don't want this to be my lawyer. First off, I never hired him.
I told you we'll talk about that.
Doctors testified that he was not mentally fit to stand trial. By June 2013, a visiting Dane County judge accepted a plea of no contest due to mental disease or defect. The robbery charge was dismissed, and Donegan was ordered committed to a secure mental health facility for life. This outcome closed the case while ensuring he would remain under treatment and supervision. In September 2012, 23-year-old Erin Salmon drove the wrong way on Interstate 94 for more than 2 miles with her headlights off. Earlier that night, prosecutors said she had been drinking heavily and was involved in 2 separate hit-and-run crashes before getting onto the freeway. Her drive ended when she collided with a car driven by off-duty Milwaukee police officer Joshua Albert, leaving both of them seriously injured.
They have a right to an attorney. I do find that they each state probable cause.
Months later, Salmon appeared in court. On February 27, 2013, a Milwaukee County judge sentenced her to 18 months in prison, followed by 2 years of extended supervision. In court, she apologized to Officer Albert's family and acknowledged the poor decisions that led to the crash, saying counseling had helped her understand the consequences of that night. The judge noted her case should serve as a warning about binge drinking and driving. Officer Albert, who suffered lasting injuries, shared that his recovery was slow and uncertain, though he hoped to eventually return to work in some capacity. On August 24, 2024, was driving home from work in East Houston, just a block from his house, when his car was struck in a head-on collision. Investigators say the other driver was Rigo Vivar, then an off-duty deputy constable with Precinct 6, who had crossed into the wrong lane while attempting to pass another vehicle at high speed. Resendez did not survive.
He was going at a very high rate of speed on the wrong side of the roadway when he crashed into the complainant's car and killed him.
In the months that followed, Resendez's family organized peaceful demonstrations, worried the case might stall because Vivar was in law enforcement. Nearly a year later, in June 2025, a Harris County grand jury indicted Vivar on manslaughter charges.
I was just happy that things were finally moving along. It had already been so much time, so knowing that anything was moving forward and that we hadn't been forgotten, that definitely felt like the delay was because the suspect was an officer and we didn't know what was going on behind the scenes.
Did the district attorney's office ever tell you guys what the delays were as far as like charging the suspect?
It was just a procedure that there was an office change from the previous district attorney to the new one, Shantier, and they were establishing all the new divisions.
Vivar was arrested in early August and appeared before a judge for the first time. His bond was set at $100,000 with conditions that he could not carry a weapon.
Insufficient. My personal thought is that it's insufficient. You certainly cannot quantify the loss of a life, but if I were to, I would not put it at $100,000.
While Resendez's family welcomed the case moving forward, they expressed disappointment over the bond amount. Vivar's next court date is scheduled for September, marking the beginning of a trial process the victim's loved ones had long been waiting for. In 2025, investigators in Wisconsin uncovered what they say was a disturbing plan by Paul VanDuyne Jr. and Andrea Whitaker. According to prosecutors, the 2 targeted women VanDuyne had previously dated, allegedly stalking them and attempting to tamper with their belongings. Court records describe break-ins, water bottles, and even toxic substances placed in vehicles. One victim was hospitalized for over a month, which prompted authorities to launch a large-scale investigation. By summer, both counties where the incidents took place filed serious charges. In Rock County, VanDuyne faced attempted homicide, aggravated battery, stalking, and related felonies, with bonds set at $37.5 million. Whitaker's bond was $15 million. In Dane County, VanDuyne was charged with conspiracy to commit homicide and stalking, with a $10 million bond, while Whitaker faced similar counts along with aiding a felon, with bonds set at $4 million. In early August 2025, both entered not guilty pleas.
She was a student, otherwise law-abiding person. She has no prior failures to appear. We are asking that the court reduce her bail to $10,000.
She's being charged with conspiracy to commit the crime of first-degree intentional homicide. I think the court needs to take into consideration, one, there's an incentive to flee simply based on the exposure of that. What she does possess is an extreme danger to the public.
During the hearing, Whitaker's attorney asked to have her bond lowered, but the judge denied the request, citing the severity of the allegations and public safety concerns. The case is now moved toward trial in both counties. In February 2023, a peaceful afternoon in a quiet San Antonio neighborhood turned into tragedy. 81-year-old Ramon Najera, a U.S. Air Force veteran, and his wife Janie had gone to visit a friend on Depla Street, planning to drop off some clothes for tailoring. It was a routine errand, one they had done countless times before. As the couple walked back toward their car, barking erupted from a nearby yard. Within moments, two large dogs managed to break free from their enclosure and charged toward them. In the chaos that followed, both Ramon and Janie were attacked. Neighbors who heard the commotion rushed outside, calling 911 and trying to help until emergency crews arrived. First responders, including San Antonio firefighters and police, quickly reached the scene. Firefighters used their tools to keep the dogs back, while paramedics worked desperately to reach the victims. The injuries were severe, and both Ramon and Janie were rushed to University Hospital. Despite doctors' efforts, Ramon did not survive. His wife was left badly injured but alive, forced to face the heartbreak of losing her husband in such a shocking way. Soon after, Animal Care Services, ACS, and the San Antonio Police Department secured the dogs, which belonged to the couple's neighbors, Christian Moreno and Abilene Schneider. The dogs were removed from the property and later euthanized. Investigators learned that these same dogs had a history of aggression. They had been previously quarantined by ACS following another attack just weeks earlier. Among the first officers to arrive that day was Officer Jesse Mendez, a 7-year veteran of the San Antonio Police Department. He later testified in court about what he witnessed when he stepped out of his patrol car, describing the chaotic scene, the ongoing rescue, and the homeowner's response.
Our officers with the San Antonio Police Department issued body-worn cameras.
Yes, sir.
Were you issued a body-worn camera that day?
Yes, sir.
Was it operational?
Yes, sir, it was.
Was it able to record the events that unfolded as you arrived on that Depla address?
Yes, sir.
Now, Officer Mendez, even though you were not the primary reporting officer, did you write a report?
Yes, sir. I contributed a supplement report from actions on the call.
May I approach the witness room?
Yes.
Officer Mendez, let me show you what has been marked for identification purposes as States 22. Would you kindly take a look at 22 and tell me if you recognize what it is?
Yes, sir. This is my supplement report for the call.
Do you think it would be helpful to have it with you in case I ask a question you may not know the answer to refresh your memory?
Yes, sir.
Okay, so I ask that you do that if necessary. Please don't read out loud from it, okay?
Yes, sir.
All right, Officer Mendez, you told us that you arrived on Depla Street that Friday, February 24th of 2023.
Yes, sir.
Do you remember what you saw upon first arriving?
Yes, sir. Upon my arrival, we were scanning the area to make sure the dogs were still not on the loose. We were told that they were already in the fence area or the owner's home area. We exited our vehicle. The first thing I remember is seeing blood everywhere, and of the crime scene where the incident took place. There was a lot of blood. There was so much blood you can taste it in your mouth.
What do you mean by that, officer? Taste it in your mouth?
It's like the taste of iron in the air from the amount of blood that was at the crime scene.
So, are you saying that there was so much blood, it was like literally in the air?
Yes, sir.
Wow, okay. So, you told us that you were told the dogs had already been put up?
Yes, sir. Upon arrival, they told us that the dogs were already secure in the home, or they had ran back to the home. So there was actually a blood trail leading back to the house. So followed the trail. That's where I made contact with Mrs. Schneider.
Okay. So let's kind of break that down a little, officer. You said that when you first arrived, you were looking for some dogs.
Yes, sir.
What was the call for? What sent you out to Depot?
So I was actually returning back to the South Patrol service area from an arrest downtown. That's when we had heard an emergency tone go off on our radios. That is a tone that goes off for either officer in trouble, or any kind of serious call, whether it's a shooting or so on and so forth. The emergency tone went off on my radio, said that fire was in trouble at that call. So me and my partner decided to respond.
Okay, so you arrived, you told us about you said you were able to contact someone named Miss Schneider.
Yes, sir.
Were you able to get a good look at that person?
Yes, sir.
And is that person present here today in the court?
Yes, sir.
Would you kindly identify her by something that she might be wearing?
It's this young lady right here, sir, with the brown, tan, long sleeve shirt.
Thank you, Officer Mendez. May the record reflect that the witness has identified the defendant.
Yes, the record will so reflect.
His body-worn camera captured his interaction with Schneider, who immediately asked if she was in trouble. Mendez confirmed that she admitted to owning the dogs and acknowledged their past incidents. The case deeply shook the community. People questioned how such dangerous dogs had been allowed to remain in the neighborhood, despite prior warnings. Months later, both Christian Moreno and Abilene Schneider were arrested and charged with dangerous dog attack, causing death and injury to an elderly person. In August 2024, they pleaded guilty to the fatal attack on Ramon Najera. During the punishment phase, Janie Najera took the stand and spoke tearfully about her loss, describing her husband as her lifelong companion and a kind, gentle man who had served his country and cared deeply for his family.
My name is Juanita G. Najera. I am the widow of Ramon Najera. I would have never imagined that I would be calling myself a widow at this time of my life and in this tragic way. PTSD is now something I will have to deal with the rest of my life. Extreme loneliness and emptiness will also be a part of my life. You both took a big part of my life away. You took my better half away. When my husband was brutally and unexpectedly taken from me, I was blessed to have my daughter, Anna. She lives here in San Antonio. She took me into her home and took care of me. She would help me bathe. She would feed me, take me to my appointments. And you know why I needed all that help? Because when your dog attacked me, I could hardly walk. My whole body would tremble. I could hardly get out of bed without any help. I had to have help every day. My son, Carlos, a retired Marine, he had to put his life on hold. His family, he had to come down and take care of me. All my financial needs, he helped me with everything. He also provided meals for me. To this day, my daughter Anna, she's still helping me. And my son, even if he's in San Diego, he calls me. He calls me every day to find out how I'm doing. It's been hard for me to depend on their help for whatever I need. From going to court, doctor's appointments, and other needs. My son's in California, he still calls me and keeps in touch with me. It's been hard for me. I found myself feeling so depressed and weak when they had to leave me. I remember saying goodbye to my son when he left, and I held on to him, and I cried, and it broke his heart to leave me behind. But he had a family to take care of, and a job, and And being with me 2 months, he took off to be with me. My daughter Lily, she also took part. She took care of me. She would clean my house. My son Ramon, he would take care of the yard for me. All of them, during this critical time, have helped me so much. All of them have felt the stress that you guys caused on us. And you already got your sentencing, but you have left an everlasting impact in our lives. You took my husband's life. I feel that you are serving what you deserve for the crime you committed. Indirectly, it happened, but you could have prevented it. You could have done something. You could have realized that those dogs needed to be put down. And I think you got the adequate punishment. And right now, there's somebody that should be sitting right there next to you guys. And it should be the city. The city should be there sitting next to you guys because they're guilty too. And I'm glad that Judge Manson, I know that the Lord was with you when you made this decision, and it was hard for you too. But I thank you.
On September 20th, 2024, 18 years in prison for Christian Moreno and 15 years for Abilene Schneider, along with restrictions preventing them from owning dogs in the future. Even after sentencing, the tragedy continued to resonate. The Najera family filed a civil lawsuit against the city, arguing that animal care services had failed to act on earlier complaints. The case was eventually dismissed, but it led to renewed discussions about dangerous dog laws in Texas. A proposed bill, the Ramon Najera Act, ought to strengthen penalties and oversight for owners of aggressive dogs. Although it was later vetoed, it sparked local policy changes and increased public awareness about the issue. In late August 2025, a family trip to Atwood Lake in Tuscarawas County, Ohio, turned into a devastating tragedy. Ruth Miller, 40, from Millersburg, and her husband Marcus Miller, 45, arrived at the lake on Friday, August 22nd, along with their twin sons, a daughter, and youngest son, Vincent. The family planned a weekend getaway that relatives later described as faith-driven, with the couple expressing unusual spiritual ideas in the days before their arrival. In the early morning of Saturday, August 23rd, 2025, Ruth and Marcus walked to the lake's edge near a dock. Witnesses later reported that the couple had been speaking about testing their faith and believing that God would protect them. Marcus entered the water, attempting to swim toward a sandbar, but he never resurfaced. Ruth returned to the campsite where her behavior became increasingly erratic. Sometime later that morning, she placed youngest Vincent on a golf cart and drove toward the dock. According to investigators, she believed she was acting on divine instruction. Afterwards, she returned to the campground and drove the golf cart into shallow water with her older sons and daughter on board. They escaped safely and immediately sought help. At approximately 1:30 p.m., park staff and bystanders called 911, prompting a large search and rescue response. Rangers, deputies, and divers began combing the lake for Marcus and Vincent. By the evening of August 23rd, divers discovered Vincent's body near the dock. The following morning, August 24th, search teams recovered Marcus's body about 50 yards away in deeper water. When questioned by deputies that afternoon, Ruth appeared calm and detached. She spoke about hearing God's voice, being tested, and fulfilling what she believed to be a divine purpose. Detectives soon determined that both deaths had occurred under her supervision. She was taken into custody and later charged. On September 5th, 2025, the Tuscarawas County Grand Jury returned a 7-count indictment against Ruth Miller, including aggravated murder, felonious assault, child and 3 counts of domestic violence related to her surviving sons and daughter. Prosecutors stated that if convicted, she could face life in prison without the possibility of parole. Her arraignment took place later that month before Judge Michael Ernest.
You're here today because The Tuscarawas County grand jury met and concluded that they should return an indictment against you. Now, an indictment is a charging document that comes about after the grand jury meets with the prosecutor, hears evidence from the prosecution's standpoint, and concludes that there is at least probable cause to charge someone with a felony crime. It's a right that all Ohioans have. And in this case, essentially think of them as like a check on the government. They got to make sure that there's at least probable cause before someone has to answer to a felony crime. Ms. Miller, in this case, the grand jury returned an indictment that consists of 7 counts. We're going to read through those. Count 1 of the indictment is the offense of aggravated murder. It is what's called an unclassified felony in violation of Revised Code Section 2903.01C and 2929.02A of the Revised Code. It provides here that on or about August the 23rd, 2025, here in Tuscarawas County, that the grand jury found that there was probable cause to believe that Ruth R. Miller did purposely cause the death of a child victim designated as victim 1, who was under the age of 14 years of age at the time of the commission of the offense. And they go on to specify that the birth date for the child is October the 12th of 2020. Count 2, murder. It's also an unclassified felony under 2903.02B, 2903.02D, and 2929.02B of the code sections which they cite. The grand jury again concluded that there was probable cause to believe that you, the defendant in this matter, on or about August the 23rd of 2025, unlawfully did cause the death of victim 1 as a proximate result of the offender committing or attempting to commit an offense of violence that is a felony of the first or second degree, known as felonious assault under 2903.11A1 of the Revised Code. Count 3. It's an offense known as felonious assault. It's a felony of the second degree under 2903.11A1, 2903.11D1A. Again, the grand jury concluded that there was probable cause to believe that you, the defendant, on or about August the 23rd, 2025, unlawfully did knowingly cause serious physical harm to child victim 1. Count 4. It's an offense known as endangering. It's a misdemeanor of the first degree under Revised Code Section 2919.22A E2A of the Revised Code. The grand jury concluded that the defendant, on or about August the 23rd of 2025, unlawfully was a parent, guardian, custodian, person having custody or control, person in local parentis, under 18 years of age, who did create a substantial risk to the health or safety of a child victim, in this case is designated child victim 2, by violating a duty of care, protection, or support. Count 5, domestic violence, a misdemeanor of the first degree under 2919.25A D2 of the Revised Code. It says here that on or about August the 23rd of 2025, that you unlawfully did knowingly cause or attempt to cause physical harm to child victim 2, a family or household member. Count 6, domestic violence, a misdemeanor of the first degree under 2919.25A D2. Again, the grand jury concluded that you, the defendant, on or about August the 23rd of 2025, unlawfully did knowingly cause or attempt to cause physical harm to victim 3, a family or household member. Count 7, domestic violence, a misdemeanor of the first degree under 2919.25A2. Again, the relevant date, August the 23rd of 2025. Grand jury concluded that there was probable cause to believe that he unlawfully did knowingly cause or attempt to cause physical harm to child victim 4, a family or household member. Those are all of the counts of the indictment, Ms. Miller. I have the original indictment in front of me. A copy of this indictment should have been provided to you at least 24 hours in advance of this hearing. Did you in fact receive a copy of this indictment 24 hours in advance of this hearing?
The courtroom was silent as he read each charge aloud, the most serious accusing Miller of purposely causing the death of her youngest son. Represented by defense attorneys Ian Friedman and McLean Grant, Miller entered a plea of not guilty by reason of insanity.
Okay. Ms. Miller, from this point on, I'm going to be directing my attention to your attorneys. I believe Attorney Friedman?
Yes, Your Honor. Thank you.
My question to you then is, does there need to be any further reading of the indictment penalty sections that apply, the statutes under which your client is charged, various constitutional and statutory privileges apply, as well as possible pleas?
There does not need to be a reading.
Thank you. And those will be indicated as waived. I'm also aware, Ms. Miller, that your attorneys earlier had filed on your behalf, as required by law, if someone intends to do this, a notice of the defendant's plea of not guilty by reason of insanity. I'm going to turn to Attorney Friedman just to confirm that's in fact the plea that should be entered in this case.
That is in fact the plea that we are entering by right at this time.
Her lawyers confirmed they had filed the necessary notice to pursue an insanity defense, which would require psychological evaluation and expert testimony.
The next issue that we would typically be addressing at this time is the issue of bail. I always hear from the state first. I will certainly allow your attorneys to be heard on that issue, but I always start with the state, and after I hear from the state, I'll hear from your counsel. Brian.
Thank you, Your Honor. This morning we did file a motion to deny bail under Revised Code 2937-222, and we would ask that that be set for an evidentiary hearing. Further in that filing, we moved for a no contact order with regard to the surviving victims here. That was imposed at the municipal court. We would ask that that be imposed until further considered at the evidentiary hearing.
Attorney Friedman, do you wish to be heard?
I do. Thank you, Your Honor. Your Honor, I am in receipt of the motion to deny bail and motion for no contact order. I would also concur that a evidentiary hearing need to be heard. I would ask by defense motion that hearing be continued so that we have adequate time to prepare for it.
Thank you. Thank you. Ms. Miller, by law, that based upon the request that has been made by the state, I'm going to hold you in the Tuscarawas County Jail without bail. I typically would have to have a hearing within 3 days, but your attorneys made it clear to me beforehand that they intend to challenge that motion, but they need some time to prepare for it. I intend to give them that time to do that, so I'm not going to set it within those 3 days based upon your attorney's request, but at the conclusion of this hearing, I'm going to coordinate with your attorneys, with the state of Ohio, to make sure that they have the adequate amount of time that they need to secure witnesses to be here at that hearing. So we're going to take care of that, but we're going to make sure that we set it as soon as possibly can.
Prosecutor Ryan Steyer requested that Miller be held without bail, citing the severity of the charges and the danger to surviving family members. The court agreed, ordering that she remain in the Tuscarawas County Jail pending further hearings. A no-contact order was also issued, preventing her from communicating with her remaining family. As of October 2025, Ruth Miller remains in custody awaiting competency evaluations and future hearings. Prosecutors have indicated they will seek the maximum penalty if she is found competent and convicted. The quiet Amish Mennonite communities of Millersburg and Tuscarawas County continue to grieve the loss of Marcus and young Vincent, struggling to understand how a weekend meant for faith and family ended in such heartbreak. In August 2025, a heartbreaking case shook Detroit when 53-year-old Mario Dwayne Green was accused of killing his ex-wife, 40-year-old Latricia Green Brown, at Henry Ford Hospital where she worked. On the morning of August 22nd, Green reportedly arrived at the hospital under the pretense of returning her belongings. The couple had a troubled history marked by harassment and fear, with Latricia having filed for protection earlier that summer. One request for a restraining order had been denied, but another was later approved in July, though Green was never officially served. That morning, an argument broke out between the two in a basement corridor, leading to a chaotic scene that prompted an immediate lockdown as staff and patients ran for safety. After the incident, Green fled the hospital in a white Dodge Charger, which police later found abandoned. The following morning, August 23rd, officers located and arrested him on Detroit's east side without resistance. As investigators pieced together the events, they identified 54-year-old Anthony Lee Lamont Barnett as a suspected accomplice. Authorities allege that Barnett helped Green after the crime, advising him to discard his phone, purchasing a prepaid burner phone from a nearby Walmart, and misleading police about Green's whereabouts. On August 25th, prosecutors in Wayne County formally charged both men. Mario Green faced multiple counts, including first-degree premeditated murder, aggravated stalking, possession of a firearm by a prohibited person, and several firearm-related offenses. Barnett was charged with accessory after the fact and lying to a peace officer during a violent crime investigation, along with a habitual offender enhancement.
Calling case number 250-595-8801. This is the case of the people of the state of Michigan versus Anthony Lee Lamont Barnett, who's charged with count 1, accessory after the fact to a felony, count 2, lying to a peace officer, violent crime investigation, with an habitual offender, second offense notice. I'm also calling case number 250-595-8901, which is the case of the people of the state of Michigan versus Mario Dwayne Green, who's charged with count 1, homicide, murder, first degree, premeditated, count 2, firearms discharged in or at a building, count 3, aggravated stalking, count 4, weapons, firearms, possession by a prohibited person, count 5, weapons, felony, firearm, count 6, weapons, felony, firearm, count 7, weapons, felony, firearm, count 8, weapons, felony, firearm, with an habitual offender, fourth offense notice. Will the parties please identify themselves for the record?
Good morning, Your Honor. APA Larry King for the people on both files, P78774.
Good morning, Your Honor. Jennifer Coldthirst, P52876. I am here on behalf of Mr. Anthony Lee Lamont Barnett. Sir, state your name.
Anthony Lee Lamont Barnett.
Good morning, Your Honor, to you and your staff. Brian Berry, P76788, appearing on behalf of Mr. Mario Green.
All right. Mr. Barnett, can you please state your name?
No,
Green. Barnett, Anthony Lee Lamont Barnett.
Green.
And Mr. Green, can you state your name as well?
Mario Dwayne Green.
All right. Thank you both. All right. Counsel Coldthirst, how would you like to proceed?
Your Honor, I'd like to set this for a preliminary examination.
Right. And while it looks like Mr. Barnett was arraigned on the warrant of August 25th, that would mean his 21 days would be September 17th. All right. And Attorney Coldthirst, while I believe that there's good cause for both defendants, I'm going to ask your client the same. So, Mr. Barnett?
Yes.
All right, sir, did you hear kind of what I just went through? I'll lay it out for you. So, again, Attorney Coldthirst has just been appointed to your case, and I know she's just spoken to you within the past few minutes. She, as well, will need additional time to, 1, obtain the discovery for your case, 2, time to review that discovery, and 3, time to review that discovery with you in preparation for your preliminary examination. Having said that, you have a right to have your preliminary examination within 21 days of being arraigned on the warrant. But to give your attorney time to go through these things, she has requested. No, I shouldn't say that you requested, Attorney Coldthirst. I think I established that I found that there was good cause. But if I'm correct, you're asking to go beyond the 21 days for that. Am I correct, Attorney Coldthirst?
Yes, Your Honor.
All right. So with that, Mr. Barnett, do you mind just going beyond 21 days so that your attorney has time to look at those discovery materials and review them with you?
Yes, ma'am. Yes, sir.
All right. Thank you. So both defendants are going to waive the 21 days. Having said that, I am looking at a potential date for this preliminary examination, and Attorney King, I should ask you, for Mr. Barnett, these charges are, I don't see that this will be one examination. It looks like two, but I think you mentioned there are probably going to be overlapping witnesses. Am I correct?
That's right, Judge. I would agree that it's two distinct examinations, but there's witnesses that overlap, specifically from the investigating officers.
Okay. How many witnesses do you have for Mr. Barnett's case?
Between 2 and 3, Judge.
And then how many do you have for Mr. Green?
Between 4 and 5, and the 2 and 3 from Mr. Barnett's will also be needed in Mr. Green's. So I'd say it's an additional 2 to 3. Additional 1 to 2, sorry.
All right, so for that 2 to 3, how long are you looking at? I'm trying to gauge how long it's going to take for these two exams within the day.
So Mr. Barnett's examination, I anticipate being the shorter of the two.
Clearly.
I could probably wrap that in an hour. I would need additional time, maybe up to 2 hours, to present the evidence for Mr. Green's preliminary examination. And that's assuming we don't have additional delays, lengthy crosses, or lengthy arguments.
During their first court appearance in early September, both defense attorneys, Brian Barry representing Green and Jennifer Coldhurst representing Barnett, requested more time to review evidence and prepare, as they had just been assigned to the case. Both defendants waived their right to a preliminary hearing within 21 days. Assistant Prosecutor Larry King explained that many witnesses, including detectives and hospital employees, would overlap between the two cases. The judge agreed to schedule a joint preliminary examination for November 6, 2025 at 11:30 a.m.
Regarding Mr. Anthony Barnett, defense is respectfully requesting a downward modification of the $100,000 cash bail. Mr. Barnett is 54 years old, unmarried. He is the father of one child. However, he has raised 6 others and has 15 grandchildren. He did attend high school. He went up to the 12th grade. He's currently been working full-time with a company out of Fraser called Specialty Steel Treatment. He's a furnace operator and a blaster. He has strong ties to the community. He could stay.
You're breaking up. We can't hear you.
Attorney Coldhurst?
Pardon?
We couldn't hear you.
Yes.
I'm not sure if you're moving around. If you are, you might want to stay still for a moment. Try that once again. We couldn't quite hear you.
My client is not a flight risk. He can reside with his godbrother, Marlon Cook, whose phone number is 313-289.
Well, I don't think you need to do quite that at the moment, but go ahead. Keep going.
Yes. And the godbrother resides in the city of Warren. My client, again, is responsible for continuing his employment so that he will not have to depend on the government to survive. I understand he has been habitualized as a second offender. However, it appears that his last contact was way back in 1990. Your Honor, my client does not use or abuse any controlled substances. He doesn't have any mental health history. However, since his confinement in the Wayne County Jail, he has been very low in spirits, depressed, probably needs some medication to overcome this confinement in a secured facility, he is respectfully requesting Your Honor to please give him the opportunity to post a more reasonable bail. The $100,000 is excessive.
Prosecution?
He has no violent contacts in the past, meaning violent convictions.
Prosecution?
Yes, Judge. My argument in this is going to be the same as was presented at arraignment and at the bond redetermination hearing, and that's this. I believe that Mr. Barnett is an unreasonable flight risk based on the allegations in this case. It is alleged that after the death of the victim in Mr. Green's case, Mr. Green called Mr. Barnett and explained to him what was going on. It is alleged that Mr. Barnett advised Mr. Green to ditch his cell phone because the police may be tracking it. Mr. Barnett then went to Walmart in Roseville and bought a burner cell phone that was recovered in his home, where he and the defendant, Green, were both arrested. After he had lied to the police about knowing or not knowing the whereabouts of Mr. Green, you couple this with the lengthy list of outstanding traffic warrants that were out for Mr. Barnett at the time of his arrest, and it just shows a pattern here, Judge, of a person who does not come to court, does not follow through, knows how to evade police, knows how to evade arrest, and has no problem lying to law enforcement. I think he is an unreasonable flight risk. I believe bond is appropriate under these circumstances, and I ask that bond remain as is.
Barnett's lawyer asked the court to lower his $100,000 cash bond, citing his strong family ties and employment history, but prosecutors argued he posed a flight risk due to his alleged interference in the case and prior record.
Whenever there's a request for a bond modification, the court has to consider two factors. One, whether the defendant is a flight risk. I am concerned about that. Given these charges, the charges in and of themselves cause me concern that he's a flight risk, in that they are, in effect, charges regarding really avoiding prosecution, and as well as lying to the police, or at least these are the allegations. Again, I've heard no testimony thus far, only allegations, not testimony. So these are only charges. However, the nature of the charges themselves are quite serious. One, and they seem to indicate a pattern of attempting prosecution and helping not only to avoid prosecution, but helping to avoid apprehension altogether. So I'm concerned about my number one factor, or the number one factor, flight risk. In addition, the other factor the court has to consider is safety of the public. I'm concerned, again, these charges, I have to take this case on its own, but it's related to another case regarding alleging a homicide. And the charges for Mr. Barnett are such that it is alleged that he is helping someone who is charged with murder, in effect, to avoid, again, being apprehended by the police and avoid prosecution. Those things cause me concern for the safety of the public as well. I would note also, Mr. Barnett does have a prior conviction, and while it is from some time ago, I would note that it's for unlawfully driving away an automobile. So again, that's a flight issue right there as well, but that's another concern. In addition to that, I would note when he was arraigned on the warrant regarding this case on August 25th, the magistrate who handled the case on that date set a bond of $100,000 cash as surety. I would note that Mr. Barnett was then given a bond redetermination hearing before the Chief Judge of 36th District Court, our own Judge William C. McConaughey. Judge McConaughey saw fit to have the bond continue. I'm not sure if I've heard anything different than those two people had, but based on what I have heard today, I'm concerned, especially for the two factors that the court has to consider, flight risk as well as the safety of the public. And so for that reason, I'm not going to modify the bond. The bond shall remain as is.
The judge denied the bond reduction, citing public safety concerns and the seriousness of the charges. Both men were ordered to undergo evaluations through the defendant screening unit while awaiting their next court date. As of now, Mario Green remains in custody, facing the possibility of life in prison without parole if convicted, while Anthony Barnett faces up to 15 years for his alleged role in helping Green after the incident. The community continues to grieve the loss of Latricia Green Brown as the case moves toward its next hearing in November 2025. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.